directed the district council to have a full signed collective bargaining agreement between the council and the Wall Ceiling Association considered by the delegate body. That meeting will take place on Thursday, the 25th. This morning, I sent an email to the general counsel of the union, Jim Murphy, telling him that I was formally recommending under paragraph 5H of the stipulation of order that the district council delegate body consider written procedures required by section 20 of the bylaws that will determine the manner of consideration of collective bargaining agreements going forward. And I also recommended under 5H that the vote on the Wall Ceiling contract be by roll call vote, and that the procedures that will be taken up by the delegate body require that any vote relating in any way to collective bargaining agreements be by roll call vote of the delegates. It's a fundamental tenet of democracy, I believe, that constituents see how their representatives vote. And this is something that's going to make the district council stronger, and it's a way to combat corruption. It is a strongly functioning democracy here in New York. And I can't say that New York City has reached that point yet. If you've read my private reports to the court, you know that I've criticized the governance of the council. There is still great room for progress. There is, I think, an urgency to the situation now for a variety of reasons, not the least of which is the pendency of these important collective bargaining agreements, but that I don't feel that we can wait any longer to intervene in this experiment of democracy that there's been over 12 months now. I've observed many meetings that left me very greatly disappointed in the involvement of people, beginning with their preparedness, their ability to persevere through 3, sometimes 4-hour meetings, the manner in which people conduct themselves, both from the dais, from the floor. And the sad part about it is that if the district council can't conduct its own affairs, that means that other people have to become involved, whether it's me, whether it's Chair Furman, and right now, both of us. I don't know what that says for the future of the district council. I have not wanted to intervene on a micro level every time I've seen something bad in the delegate meeting. That represents a failure of democracy. It represents a failure of the democratic system. As I said to Judge Furman in the last couple of weeks, it's a cut against the district council. And I don't want the district council to die a death of 1,000 cuts. So I have stood back and I have observed. I have watched the delegate meetings. I have reserved judgment on them. I have occasionally opined about areas where they need to improve meetings and the reports. But I think right now the district council is at a crossroads. It's either going to get it together and fulfill, I think, everybody's vision of what democratic process looks like, or other people are going to run this union for a very long time. Now, I just also wanted to briefly touch on the status of the MWA situation. I know it's been an ongoing saga. There is discussion of the so-called global settlement involving the district council, the MWA, and the benefit funds. Right now, there is a small group of trustees, the so-called non-conflicted trustees, on the board of the benefit funds, who have hired a special attorney, I'm not using McGuire on this one, to give them an opinion as to whether they can act in a certain way, which will involve forgiving certain debt of the MWA in order to facilitate the execution of a 10-year collective bargaining agreement between the district council and the Manufacturers and Workers Association. The matter has lingered for a couple of weeks now. I sent an email to the co-chair of the non-conflicted trustees, David Weaver, this morning. He has not responded yet, although I anticipate that he will within the next day or so. There is expectation that the global approach is best, that the MWA probably will not sign a collective bargaining agreement without it. So this is an important decision that the trustees, and they're all employer trustees, by the way, the district council trustees are conflicted on this. So it's a decision that is very important and I expect to be made fairly soon. Right now, there is no deal on the MWA.
Can you expand on that? You just said about them being conflicted on the council side?
Yeah, the conflict of interest lies in the fact that the district council trustees who sit on the board of the pension fund are obviously also involved in the arbitration process. There was the award from the arbitrator of $8 million. The process is sitting down at the negotiating table, trying to negotiate a CBA going forward. The employer trustees have none of those conflicts because they're not involved in the arbitration. They're not involved in negotiating a collective bargaining agreement. There's no specter of a prohibited transaction. So many months ago, the district council trustees under advice of council recused themselves, and they are relying on the remaining fiduciaries, so the employer trustees, to act in the best interests of the beneficiaries. Now, there was an interim agreement to use approximately $1.2 million that had been contributed by the MWA to the funds, which had been held but was not applied by the funds, to go to the medical benefits of affected MWA employees. That deal was struck right at the verge of the deadline of April 1st for additional members to lose their benefits. And there were two tiers of beneficiaries under that agreement. Some members were granted 500 hours of coverage, others were granted 250 hours, depending upon how they fell in the scheme of things.
That's why the trustees made that decision.
The employer trustees, the district council, and the Hollow Metal trustee all participated in that agreement, but it was inked the day before the deadline when over 100 members were going to lose coverage without that deal. So that's $1.2 million that's going to be applied for medical benefits for those members and their families.
Who are the current trustees and the Hollow Metal trustee?
Vincent Gallo and Edmund Greco are the two employer trustees on Hollow Metal.
And on the union side?
Mike Malillo is certainly one of the trustees. I believe Chris Wallace is another union trustee. Or maybe a third one, still in line at the moment.
Is Murphy consulting with this special attorney and whoever that special attorney is, and did that special attorney work out this agreement?
The special attorney was deeply involved in working out the interim agreement to continue the coverage. Murphy was involved.
So Murphy and the special attorney are consulting that.
They
I
are
think he's going to be tainted by Murphy.
No, the district council has an interest in getting coverage for its members, so they strongly advocated for continuation of coverage using the $1.2 million that had been paid by the MWA, which had just been held by the funds. And so, yeah, there is ongoing discussion involving multiple attorneys.
Might I suggest in the future it might be a good idea for Murphy and this other lawyer, whoever he or she is, to stay the hell away from each other because Murphy has made so many mistakes and is tainted by his mistakes.
Well, we'll take each issue as they come, Tom, all right? I want specifics for every proposition that we're going to talk about today, and as many facts as we can get into the record, so that people who are listening to this and perhaps watching it can make their own judgments rather than just rely on what people think about the situation. Okay, Kevin?
Your global settlement proposition, or the global settlement proposition, would that also include making the members that lost their benefits back in, I believe, May 11th of last year, making them square from May 11th forward, or will their benefits, will they have lost, say, the 8 or 9 or 10 month period, they're not going to receive retroactively their benefits to be made square?
I think the cutoff period was January 1, so I don't know that it goes back before that, but I can certainly check on that.
I'm pretty sure, like, certain outfits, like the Remies of the world or whatever, May 11th to May 12th, that's when they actually switched from field benefit to in-house benefit to shop benefit, even to the field days. So from May 11th or May 12th, I'm not sure of the exact date, will the global settlement make those members that lost those benefits, or the percentage of those benefits from that day forward, make them square, you know?
The answer to that question might actually be on the district council website. I know some of you fellows don't go there that often, but I think the terms of the interim agreement were posted on April 1st or 2nd. So check that first, and we'll check it and make sure that that's something that's answered. Bill?
Mr. Walsh, when you mentioned the MWA agreement with the employee trustees, the hollow metal guys, who precisely is from the district council that was on that team? That's what I'm wondering.
You'd have to check the signature page, but my recollection is that either council or perhaps one of the fiduciaries from the district council signed on that.
Thank you, sir.
But there is a signature page on it, and I have it, and if you get back to me, I'll forward it to you.
Thank you.
Okay, Dave.
I just wondered about the filming. Is this going to be on the website, or what is the filming for?
That's my intention. There's no other reason, I think, to film it other than to get people to feel like they're part of it. So, you know, and I invited anybody who had video on their own and do what they want with it.
Is that picking up the audio? You're not even-
No, those are pretty sensitive. They should be able to hear everything. So, go ahead.
I made an attempt, obviously I didn't make the last meeting and I apologize, but I made an attempt to listen to it online. Unfortunately, there's no pause, there's no way of stopping at a particular point, so if you get kicked offline or you just can't sit there for 4 straight hours, you have to continuously
This is on
listen
the
to the
district
whole
council
thing
website?
over and
This
over.
is on the DC website?
Yes,
All right, we'll
last
see.
meeting.
I didn't know
That's
that.
crazy,
No, it-
that's ludicrous.
They need to break it up.
Right.
That's very-
So I could be able to pause, come back.
Well, like
I
they
said,
did for the Jarvis debate, they need to segment it.
I got kicked off and I had to start all over again after 2 hours.
I agree with that. That's crazy.
Right.
Let's open it up to any issue, any question you have, any position that you have. I want this to be an opportunity for people to say what's on their mind. You don't have to ask a question. You can just say what your opinion on any subject is that relates to the funds, the district council, collective bargaining, whatever. All right, so I'll just, everybody be patient. I know we have a lot of questions. I'll work across, starting right there.
How you doing, Brian Furman?
Hi, Brian.
A lot of things to this. Let's go. 67-33% regarding the job situation. The contractor doesn't have that. What happens after that?
They will either network with other employers or they will go to the outer office with members of the council.
Okay, say they don't have the 67%, they're working 90% company, 10% from the union.
I think I misunderstood the first part. Say your question again.
67-33 that the judge.
Right.
Everybody has
currently
to.
have the May 2009 ratio. Okay, go ahead.
Okay, say for instance, John Doe Construction does not have the ratio on the job.
If they're in violation of the ratio?
Yes.
Well, that's got to be fixed. I mean, if you're above your 67%, the council has to fix that immediately as soon as they have knowledge of that.
And if the council does not fix it, you mean the council's fixing all these jobs that are not ratioed?
The prospect always remains that if the steward's not calling in a mismatch, or if the VA, if the rep doesn't get to the job, that they're exceeding the limit. But it has to be discovered by somebody, or reported by a member on the job.
And once it's reported, it's come from the council, so it's the council's job to enforce the ruling of the 67-33%.
Correct.
And if it's not enforced, a grievance is filed?
Well, if it's not enforced, somebody in this district council's not doing their job. Then it has to go to a proceeding, and they have to lay out their facts. But the bottom line is, facts have to be proven in a situation like that.
I understand, but I'm saying, from as far as I understand, it's this 67-33%. Unfortunately, what Pete Thomas, basically sold us out. It's not being so-called
Well,
updated on the job.
6733
It's not being enforced,
was,
actually.
it was a remedy that
Judge
was
Hayden called
heavily
in and said-
litigated by the association, by the district council, and the order is very detailed in terms of how we got there. And I think at the end of the process, he even invoked his equitable powers to try to fashion what he thought was a fair remedy, considering all of the different interests. But that originally, you remember, went back to the district council's failure to report to the United States Attorney's Office as they were
That
required
was
to do
Peter Thomas and
under the
Gary
consent
Rothman.
decree, that they had changed the ratio.
Yeah,
or
Peter, it was
changed.
Gary Rothman and Peter Thomas at the time.
Any dispute between an employer and the district council ultimately is settled by an arbitration if it can't be worked out.
So it has to be filed
They have
with
to
the
file
district. Is there any
grievance.
paperwork that's been filed saying that the job has not been?
Any paperwork for any grievance is filed. The contractor gets notice of it. There's pre-arbitration meetings where they bring lawyers, and they try to hash out the facts and settlements. But if it doesn't settle, if the parties disagree, then it goes to arbitration, to a neutral arbitration.
Is there anything like that at the district council going on right now in arbitration?
On a ratio for a
Yes.
job, probably. There's over 2,000 open cases right now.
So this 2,000 contract is not available?
No, 2,000 total cases. It could be for any dispute regarding any CBA. It could be brought by a member, it could be brought by a business rep, it could be brought by the IG. Any dispute regarding any aspect of the collective bargaining. It could be that somebody got the wrong pay, and telephone calls and meetings haven't resolved it. Then the arbitrator will decide. It's a dispute, and there's dozens of different areas under a CBA which could lead to arbitration, not just the ratio.
Okay, I don't want to take over the meeting. Regarding Gary Rothman, negotiations with James Murray before the indictments that was going on. Did he think he was just going to settle with James Murray and just step aside with the district council, or how did Gary play the part in this? Because I understand that, Gary knew the contractors were not going to pay us, and when he went after the contractors, he knew he wasn't going to get the money. And also what happened was, Gary was billing us at the time, and he billed us and billed it, and as far as I'm concerned, Mr. Walsh, that's a criminal act. Okay, so I don't know where Mr. Murphy stands on the lawsuit against the most powerful man in New York City, which is Brian O'Dwyer. The lawsuit, I think, was mentioned, but unfortunately, I'd like to see it if it's available. It was rumors it was in Brooklyn.
There is a lawsuit that was filed by the benefit funds against O'Dwyer University in state Supreme Court in Brooklyn a couple of months ago. I think it seeks over $8 million in damages.
How disgusting is that?
And it's a public document, so anybody who wants that complaint, they're entitled to have it.
Do you have the document?
I can get you the document, sure.
Yeah, something like that, Dennis, is, something where we'd like to know, but unfortunately, it's just not out there. I don't know why it's not posted.
That's a benefit funds lawsuit, that's not a district council lawsuit.
Okay, regarding Mr. Leary, with the multiple cash payments he accepted with the vendors, he accepted, when the vendors were saying to Maurice, listen, this is going to be $40,000, Maurice basically said, you have to charge, I'm going to charge us $50,000. Accepted the money, he split the money around. What's happening with Mr. Leary and the multiple cash payments he accepted from the numerous vendors at the district council, along with local 608?
Brian, that is the first time anybody has ever mentioned that to me.
So nobody from the IG's office, nobody from anything,
If you have evidence of that,
PJ, the benefits, the Christmas party with the chicken wings, Maurice Leary basically told the guy to add him extra money, he accepted it.
all right, well, I will investigate that till the end of time if you want to come in and start it. But that is the first time anybody has ever said anything like that.
J.C., hold on, my wheel's going. J.C. Fogarty's was the name of the vendor. Okay, numerous times it was $40,000. Next year later, it was $48,000. Maurice took the 40, gave it to the council, and the $8,000 was a split among the so-called club. So nothing's Nothing's happening, nobody...
Nothing's happening because no one has ever said a word about that phenomenon.
Okay, what's the status of Maurice Leary right now? He's just private citizen at the site safety at the JFK airport.
If he's employed as a site safety person, that's news to me, but he's not in the union.
Okay. Whose job is it to collect the money? I know Scott Danielson's involved regarding collecting the monies of the fines, the $500, $1,000. What process is going on right now?
The fact is that the only people who pay fines are people who want to stay in the union. So that's why you get people who are fined $250, maybe $500, maybe $1,000 pay their fines. If they don't pay, they're suspended, and they will be out of the union. The bottom line is the big fines are virtually uncollectible because people do not intend to rejoin the union. So when you get a big fine, such as $1 million assessed against Ford, you've got 10 more years in federal prison. He's obviously never going to be...
Unless Hillary Clinton comes out.
But
once Hillary comes out, Mike will be out too.
The fact is, though, that if there's serious misconduct, there's a legal remedy by suing for the breach of fiduciary duty. There is a lawsuit pending right now in federal court against Mike Ford and John Green and others. It's a civil RICO case where they are seeking money damages from Ford and the other defendants for their breaches of fiduciary duty as fiduciaries of the benefit fund.
Okay, is there a way we can get these lawsuits do we have to go down and pay 25 cents per copy, or do we...
That's available on Pacer. There's a docket number, and I bet Dan has it.
Okay, thank you, Dan. One more question. Regarding the contractors that are fined, what's the status of numerous contractors that have been fined?
When you say fine, what do you mean?
Say, for instance, a contractor got caught giving cash. They're fined $3,000. Is the district council going after them for $3,000?
You mean as an arbitration award?
Or, no, as a settlement award saying that the district council found them $2,000
There's a couple of different scenarios. The benefit funds has a collection in Chuck, Virginia, which is the firm Virginia and Ambine. They have a vigorous enforcement program where before there's any legal remedy, they are in touch with delinquent contractors and they tell them, how many dollars are actually owed to the benefit funds. If they don't work it out, then a lawsuit is filed or an arbitration is filed against those employers.
Okay.
Now, there's also employers who lost in arbitrations and who lost in court. As I said in one of the reports, the prior collection efforts were dismal. Arbitration awards might be filed in state or federal court, but they weren't enforced. They were routinely referred to a collections agency that really collected only about 5 cents on the dollar for every matter that was referred. So you had millions of dollars that did not generate any income through that process, but the lawyers got paid. It's completely different now. The bottom line is arbitration awards are filed in state or federal court. Judgments are vigorously prosecuted. There's been a huge clampdown on payment plans for delinquent contractors. Virginia Ambiner does a status report to the delinquency committee of the funds every month at a meeting. They routinely collect a couple of $1 billion every quarter on behalf of the benefit funds. So there is vigorous enforcement by reputable attorneys who report in detail to the board. Chuck Virginia sends out a document to the board and to me each month, which is now over 900 pages long, which in minute detail describes the status of each case, whether it's a judgment, whether it's a live litigation, whether it's a bankruptcy. So there's not a single case for the benefit funds which is not on this status report. And the same thing holds true for the pending matters of the district council.
Employees, are they allowed to be still employees of the New York District Council of Carpenters? Can the construction company still go on while they're owed so much money?
You talk about the shutdown list?
Yes.
No, the shutdown list is vigorously enforced, and there is a lot of communication between the district council and the benefit
So if
funds.
the money's not paid, they automatically shut down?
Yeah, there's a rigid policy. The employers have to pay up or they will be on the shutdown.
Okay, regarding the blue card situation of the collection of the money, now, I don't
Talking
know,
about going forward.
the one that's
dues check-off
recently,
plan?
yeah. There's independents that works in the district council, business agents, they call the contractor. I don't know, am I correct?
Keep going, I don't know
Okay,
where you're going.
they call the contractor, they call Ford, they call Commodore, they call, numerous contractors, and they tell them that Joe Schmo has not paid his assessment. So you're gonna ask Joe to get him off the job right now, or else he does not have a job. Now, that's something you know of, or something that's news, or?
Look at the, you want my view, I don't think,
I just want the truth, that's all I'm asking for, is the truth, you know?
well, what I think is the truth is my view. Is
Okay,
that
fine, that's
you-
what I mean.
You cannot force somebody to join a union, that's my view, that's the legal matter.
Mhm.
That you cannot force someone off a job. The employer, however, if they have a collective bargaining agreement, has to pay the fringe benefits and the salary on behalf of that individual. He may or she may choose never to join or rejoin the carpenters union. If he or she uses the benefit of the out-of-work list, the district council has a right to charge for that service. But I don't think that anybody has the right simply to say, you must fire him because he is not a current active member of the
You
carpenters.
understand that's still going on, right?
Yeah.
Now, it's a big joke on the inner circle where there's merits. Tell me if I'm not correct.
What do you mean, Barry?
Merits that, Tommy worked the phones this week, he collected $8,000 from the assessments, the blue cards assessments.
I don't understand that, Brian.
They get a
But they
bonus.
get bonuses.
They
They
get
get
a
elected.
bonus for getting that kind of money.
Bringing
They
the
get
money
more
in,
money,
bringing the money
but
in.
they're not talking about what they get. That's what we're
Not to
saying.
my knowledge.
Not the, okay,
That'd be nice to see.
yeah, I know. Regarding the signatures of the blue card, I know it's.
Talking the old blue card or what
The
they
old
want
blue card
now?
from-
No,
The old blue one. I didn't sign mine.
I didn't sign
Because
mine.
of things that go on. Mr. Callahan, unfortunately, he was a total disgrace, in my opinion. You want my opinion? I don't know if you do or not. But him, along with Gary, along with Brian, they knew what was going on the whole time. It seemed like it was a major scam. And that day that I got arrested in front of the district council, I had bags of flour. So Mr. Callahan should have said it to himself, Jesus, what the hell is he doing with the flour? But Mr. Callahan took it upon himself to write the judge a letter saying that I beat some guy up, literally. Okay? You know as well as I do, that's not the truth. The full version of the videotapes, we don't know. I haven't seen them to this day. Maybe you did regarding the unedited videotapes.
The last appearance of you on any video is inconclusive.
Okay, is it because the videotape was broken, or is it because Barry Security tampered with the evidence?
So the tape or the recording ends with you coming off the front desk, and then there's nothing after that.
But how could that be?
That's interesting.
How could that be? How could no legal authority have asked, where's the rest of this tape?
Well, look, at the bottom line is.
Where's the U.S. attorney?
I think you got treated badly, and you know I said that. And
Yeah, I know you said that.
I pressed the UBC to settle that case.
Yeah, but you know something, Dennis, that dragged me through, like, I think, the international president, Douglas
Well,
McCarran.
look at it, you should not have been on that desk.
No, I shouldn't have, no.
So,
But if I got.
you're a member in good standing of the union now, Brian,
I know.
all right, and that's a good thing.
I know.
I can't
Oh,
say
wait.
anything more about that, other than that I think you should have been readmitted much sooner, and that you had a valid cause to begin with.
Thank you very much, appreciate it. One more other thing, regarding signing the card and not signing, is there a legal issue there?
Yeah, I think there is.
Because what's happening is, from what I understand.
If I was an employer, Brian, there's no way I would touch your money. And my understanding is that, and I sent an email to Mr. Murphy this morning, I want a written clarification of what they intend to do. But the impression that I was left with at the last delegate meeting was that the policy was going to be that the money was going to be taken out. That there was going to be one universal signature and that copies of that universal signature were not going to be sent to every employer. If I was an employer, I would not withhold your working dues and assessments unless I had a copy of that authorization, period.
Required by law.
The lawyer that's
It's your money,
representing,
so, I mean,
the lawyer that's representing the case with the retirees,
yeah.
what's his name?
I can't recall his, but I know the name of the case.
John
yeah.
Clark?
There's a couple of lawyers.
Yeah, I know Enright's the-
Enright's one of the plaintiffs.
Yeah, we got more
With the lawyers
lawyers
for
than
district
lawyers.
council?
Harvey Martin.
Harvey Martin.
No,
Correct.
for the district council.
No, it's a federal case, and they sued the benefit funds, and the district council is now in the case. They were granted a motion to intervene.
The benefit funds lawyers,
McGuire.
McGuire, so then he hired, speaking of Mr. McGuire.
Well, wait a minute, finish your point.
Okay, he works with a guy named John Clark. I think he appointed John Clark under him.
Peter Clark?
Peter Clark, okay. I'll take Mr. Clark's secretary. But Raymond McGuire, regarding the lawsuit that he was going to be filing, I think 2 years ago for the contractors who raided us, is that going into effect, or?
I don't understand what you're saying.
You mentioned in court that the benefit funds and everybody else, that was, they were gathering together to file a lawsuit regarding the employees who cheated us out of our benefits.
Well, there are hundreds of pending litigations with Virginia and Binder against any contractor who was delinquent or who attempted to cheat funds. So there's many, many lawsuits that are pending. That is a fact.
He's got like 700.
700 pending litigations. Yeah, I mean, there's
And
like I
Raymond
said,
Ward's behind
the
it?
status report, no, he's the general counsel for the funds. They have a special collections attorney. His name is Chuck Virginia, with the firm of Virginia and Binder. He's a specialist in collections cases. He works for other unions as well, and he has a very good reputation. He's very aggressive.
Stuart Rapos, the executive director of the funds.
Former.
Former. Okay, what's his status? Is still ongoing investigations to do with the funds? Was there anything with fictitious vacation checks that were not rendered at the destination they were supposed to? Where the checks came back to the council, Stewart took the checks and gave them to another party, and then cashed the checks?
There are negotiations between attorneys involving Mr. Gravois, and that's all I can say.
Thank you for your time.
I have a question about his first question about the ratio. If you're on a job and they're not enforcing a 67-33.
District council's not.
Right. In other words, following job, when I call
They'll
it
let it
VA, right? I want to see people from the list come to that job instead of them telling me about grievance. Like, none of these guys
No,
have
they
received money
do
for
that.
it.
They absolutely, if they bring it to the attention of the contractor, the first thing that is supposed to happen is that somebody comes off the list to correct the imbalance.
If I have a problem with that, do I call you?
Sure.
All right, good. Easy enough. Thank you.
I spoke to someone in your office. Never got a call
You
back.
know how to get in touch with me.
Just saying, I made a phone call, I never got a call back. I made a call to
That ever
Townhall
happened?
too, and I never got a call back.
You call me or you email me. Right?
Hello, Mr. Walsh. My name is Reagan Rowe. I'm recording secretary for 2790. I have a question regarding the MWA global settlement that you said before. We had a meeting with our executive committee and powers that be, council reps. And we stated at that meeting that we never agreed to or even proposed a 10-year because it never came from our committee that we chose or that was put in place, which at that point they weren't involved. And it was about a month and a half ago. So even at that meeting when it was stated and then the letter went out and then we read what was on Judge Berman that there was a 10-year proposal, it kind of startles us because, again, at our level, we never agreed to it. We didn't want it. We never polled our members. So we don't even know where this came from. So again, it's a little bit disturbing. We stated at that meeting that there were other issues related to that contract because obviously, if everybody knows, we've had a little issue with the contracts, 4 pages or 5 pages ago, and then all of a sudden now they're saying that all the contracts, we have to get all the language. In our agreement, like in the firewall, if you believe what happened with the firewall, we had 3 members, one of our members from our local, our E-board, present during those negotiations. It appeared that after a certain amount of time or whatever, they weren't involved anymore, in these negotiations, and then it was baked that, here you go, this is the contract we agreed upon. These members are still in the loop. We stated at our meeting with our E-board, we have, various issues like the 80% give back. For example, like Remy has the finishers across the street, and we've asked about that. I've asked that at my level, my business reps, if any of these contracts are being negotiated. I understand that it's due process for the district council to negotiate contracts, but how is it that they're negotiating contracts without us at our level, at E-board level, even knowing, like, that there is a contract being negotiated, or we have no input in the sense of saying, well, why haven't we had the members? I heard that it was a possibility that, again, the delegate body wouldn't be able to ratify the contract depending on how the bylaws are set up, and depending on the men in the shop, the men would be able to vote on it. I don't believe that there's an animate amount of time. As what I heard with the firewall, they were presented on a Wednesday, here you go, you got 2 or 3 days to vote. The period between us being able to even hear from that representative, it appeared that the time frame was shot a little bit. Like it was a Wednesday when they did it, our E-board meeting was the following week, then he came to our meeting and said, dude, I didn't even know, they just came, and there was a money issue. So that's one of the issues that I have. The concern that I have right now is that there are any in our local 2790 contracts being negotiated, regardless of the fact that our delegate body, or we should know about, knowing that we have the favored nation clause that was a big issue. We have finishers that are in these locals also, and we've complained at our level about the wage grade. So how can we resolve this where we're involved, again, because we need to be involved. Our members of our local need to be involved. We have made attempts at our level, our delegates obviously are very involved. We have made attempts at our level with our executive delegate, and we put in the minutes for them to present themselves and come to our E-board meeting so we can get some information. At the meeting that we had with the powers that be, they asked us across the table, are they giving us information? Honestly, we get what everybody else gets outside. I'm in the field, and I hear the reps and I hear the members say the same thing. When they go to the reps and they ask the question, what's going on, we don't know anything. At our level, the same thing, we don't know anything. And then the fingers are being pointed up top. Then when the shit hits the fan, I hate to say it that way, all of a sudden now we're having this issue with the transparency.
There's 2 main things that come to mind. Number one, under the bylaws, the executive committee is supposed to be doing the negotiations on all CBAs. If your executive committee member is not keeping you informed, that's an issue. But I think that it works both ways. I think that your E-board from the local should put in writing as official correspondence to the executive committee of the district council your dissatisfaction with the present setup. And then that also gets you into the question, because I know that when the UBC had supervision, that there were shop agreements that were ratified by employees in those shops that were not presented to, although it was powerless at the time, of the delegate body. Now, I'm sure if you asked the UBC, they would say, we were in town legally, we were the supervisors, we negotiated those agreements, and we actually went the last step, and we presented the agreements to the affected members who worked in the shop. But there were shop agreements that were executed during the UBC supervision. And it raises the question now because I think it's a really important question. Who actually is affected by a collective bargaining agreement? When they mailed out in the AAA vote last year, they made distinctions about who got to vote on which contracts. For instance, the employment agreement, the one that passed, that was sent to affected members. It was not sent across the board. So I think you guys particularly have legitimate questions as to whether the affected members are adequately involved in the ratification process. And the entry point is, are you being heard effectively?
Well, that's the thing. Like I said, we put in our minutes. I'll take the hit. I've actually confronted, and I've actually had it in our board. Listen, we got to put in the minutes. We got to have this guy here. We need to know what's going on. It was stated.
All right, but you need to go beyond that. You need to write official correspondence. You can attach the minutes as an exhibit but you have to send it to the attention of the executive committee of the District Council of Carpenters as official correspondence, and say whatever the majority view is of your executive board.
Yeah, because we don't have, I mean, at this point, as I know of, we haven't polled our members, we haven't asked them, I mean, our website committee member is trying to do the best he can, but we haven't even, to my knowledge, like said, listen, what are you guys like, what is your give back, what are you willing to accept? Because I'm already hearing that in some shops, or the rumors out that they're going in that direction, like with the firewall, you have the option of going into the B plan, which is the, and you know, that's a hit.
Make a record and use the system to affect the change that you need to.
All right, there's another question I have in regard to the hollow metal fund. I was under the impression that we had a representative up top at the benefit fund, I believe, that was dealing with the hollow metal fund, where our members could be able to call and ask the questions. It was brought to my attention that apparently it's not our members that they don't have anybody, or there's nobody designated for that fund, and they're having one person that's doing the benefit fund and the hollow metal fund. So our members are leaning towards whoever they can to get whatever information. Obviously, like I said before, our VAs are being said, or they're saying there's so much we can say.
Let me tell you, on this one, if any member is calling the benefit funds and they're not getting adequate service from anybody who's on the phone, let me know.
Well,
I'll immediately bring it to the attention of the interim executive director.
Well, that's what the secretaries did mention, is that they're feeling the calls, obviously, because one of them is Hispanic, I believe the other one that we have is a temp is Hispanic. But again, it falls on our e-board to do the work that if the executive are not, or the reps are not supposed to
And if
do.
a member doesn't call somebody to complain, then nobody would ever know. But if you guys have any information that someone was less than satisfied with the handling of any inquiry over the telephone or on a walking basis, you let me know.
Yeah, because that's,
And I'll talk to Laura Kay.
that's a problem, because my e-board member, you know, when he started stepping in that direction to make sure the members, there's rumors out that he's like a bad guy now. Like, they don't like you up there. Like, he approached me and said, this is what I'm hearing. I'm like, why? Because you're doing the right thing. You're making sure that the members are informed. That's what we're supposed to be doing.
We'll move past that in a hurry. But let me know.
No problem. Thank you, Mr. Bush.
I'm Tom McGuire, retired floor cover. Concern was saying you can't get information. It's been come out anecdotally that Matt Walker has refused to give information until the delegates vote on certain things. How are you supposed to tell your delegate how you'd like a delegate to vote if you don't know what they're voting on? And I'm not talking about the light bill.
Tom,
I'm
give me an
anecdotal.
example.
Well, anecdotal, like Doc Builder has said he went looking for something concerning what's going on with Thomason, or if there's ever going to be anything with Thomason, and what's going on coming up in their negotiations. And Matt Walker told him not to the delegates vote on it, you have no right to it. Or somebody in his office. Okay, that's anecdotal. I don't know the person myself. This is what I've been told, and I've heard that from 2 or 3 other people that they've also asked Mr. Walker for things. I've been told you can't have that until the delegates deal with it. Well, there's no transparency.
Are you just talking about getting an answer to the question, or are we talking about documents being given out?
I think both. I would say both. I mean, I think it occurs to me that if you want democracy, you have to give the members a copy of the CBA, like you've made them do, and let them go through it. You can't just.
I'll agree with you.
I'm not saying you. I'm
Here's the
saying
thing. Unless there's a reason, and it has to be articulated in writing, why legally it cannot or should not be disclosed to a member of this union, my view is that it ought to be given to the member.
Can we somehow preempt Mr. Walker's negative on this, and if he's discussed it, mention it in
about Matt,
passing?
because he's a pretty careful guy, and I think he would have had to have had a very good reason. So if there's a specific situation that I can bring to his attention.
I'll send you an email tonight, I'll find out
Okay,
the actual.
then I can get an answer directly from
Okay,
him.
and I'm not done.
But in terms of policy, I think there has to be an absolute articulated legal reason for a reason regarding pending confidentiality, why a member should not
Which
have
would make sense,
information
what?
about the business.
No, I'm not done, if that's okay.
Look, that's standard practice, not just in the car.
You would think so, right? You would think that that's the way to run an operation.
Transparency.
But my point is that unfortunately, it's been standard practice in dozens and dozens of unions not to give members information because knowledge is power.
The rusty nail gets hammered down, don't you know? That's what floor covers say. We hammer nails. Now,
Well,
there are a couple other things.
you're coming up. You're coming up.
But there are a couple other things.
Understand my view on this. I think you're entitled to everything that constitutes the business of the union. And that there has to be some articulable reason, whether it's legal or business confidentiality, but I think you are at least entitled to know what the reason is why you can't have a bit of information.
Or if the
Not just a
policy-
nebulous response, well, this is the policy.
Yeah.
And then when you ask for the policy, it's not in writing, or they tell you, well, that's just the way it's always been. If there's a policy, it needs to be in writing, so that everybody can look at it, and if they disagree with it, then they can, in theory, talk to their delegate to get the policy changed, because the delegate body under the UBC philosophy has plenary power. That means they are all-powerful. They have complete discretion to do what is in the interests of the members. But if the members don't have the information, they can't have a meaningful conversation with their delegates, and nothing gets changed.
And now,
That's how democracy is supposed to work. Information and communication.
now, you and I spoke about transparency back in like January, February, and in March, I think you saw the judge in March, I think there was a March hearing that I wasn't able to get to. You had told me you were going to bring the transparency issue up, that you were upset, and I have the email, that you were upset at the lack of transparency from the district council and the lack of getting information out, and you had also told me you were going to bring that up at that hearing. And yet I looked through the transcript and I didn't see word one about that to Judge Berman. And I'm wondering why.
There's been other conversations in the reports and in other conferences and hearings we just had about the whole question of
So
transparency.
you felt it wasn't necessary that day?
I look at, if the district council is working through democratic processes, can't get its own house in order, I can make a motion to say, yes, this document or the records of this department should be accessible by the members. But that's just a district court and a monitor involving themselves in the affairs of a union that has got to become self-sufficient. And I am stuck with the notion that all this has to come from the ground up. Now, I know a lot of you guys go to the delegate meetings, and perhaps you've observed that attendance is down. You're talking about maybe 70, 75 delegates with the norm. 55.
Rubber standpoint, yeah.
Yeah, you,
At the delegate
Yeah.
meetings. We have nominations coming up next month. We have elections in June for all of the delegates who sit in the district council. You know, ask Matt Walker for the attendance records of the delegate body, see what he says. Make that part of your judgment about whether you want to vote for somebody who's an incumbent, or whether you want to try somebody
Why
else.
shouldn't it be
who's
mandatory
committed.
they have to show up? They want to be a delegate, then it
Well,
should
they
be
have a
mandatory they
three-strike
have
rule.
to show
They
up.
have a three-strike rule. But
is that 3 in a row or 3 out of a year? Or
that's just a procedural policy question. What's more important is, how does the democratic process address that? If the guy misses every other meeting, he's not in danger of being knocked out on a three-strike rule, but he's only there half the time.
Sounds like a congressman.
Yeah, that's it, they're following Congress.
Yeah.
That's it. Now, if I may, there was also, well, I don't know.
We can come back.
Brian was able to go on and on. Brian was able to go on and on and get all his questions
We'll
out.
come back.
Okay, then there's the question. Then there's also a question of
How
what the
many
gentleman brought up.
delegates do you think will quit after the next vote on the contract? How many do you think will leave town?
All of them.
Are you going to be making book on that proposition?
Can I just finish this?
Well, I was gonna go,
Excuse me,
because-
Gene, mind if I finish,
All
Gene?
right, come on. Fellas, please.
Now, then there was the question of, one of the gentlemen asked about prosecutions and suing of companies that routinely did not follow the rules and routinely cheated.
Right.
How come the U.S. Attorney hasn't prosecuted any of these people, not one, except for that Murray clown who was told by the judge, you're a hero? And on with that, how come Mike Zemsky and Jeff DeSantis, even though I was guaranteed by John Ballantyne that they were going to bring charges against them in the federal court for violating the 2287 CPA for 10 years by not going with the 50-50 and then the 67-30, they went against the judge's decree, yet no one prosecuted them. Why, if I may get an answer?
I I was a prosecutor for almost 7 years. And there are the overwhelming number of cases that get brought to the attention of DAs and U.S. attorneys don't get picked up. There's no shortage of opportunity for prosecutors, but prosecutors like well-presented cases. They like cases with multiple witnesses. They like cases with documents that are clear. They like cases that people will plead guilty to. And they have the discretion as to whether they're going to go forward with the case. It happens every day of the week in state and federal prosecutors' offices. So you can refer cases, but ultimately, there's a line assistant and maybe an agent or a detective who are going to report to a supervisor who's going to ask hard questions about the witnesses, the documents, the cost of the investigation, and the uniqueness of a case. There's all these factors that come together so that he may not even make it up to the DA himself. They may get squashed at the head of the Racket Bureau.
Well, that's really sad because we all know that for those 10 or 11, 12 years that those two guys were running my local, those steward reports are here in the building, and there are the documents right there that show one man, 13, 14, 30, 25 men.
I know that, but
There's documentation.
The unfortunate part about law enforcement has its work cut out for them, and there's a shortage of resources,
Yeah, a lot of criminals.
especially with budget cuts and sequestration.
Budget cuts, my taxes just went up 58% for law enforcement.
Well,
You're right.
The bottom line is, there's no shortage of prosecutable
58%.
cases that don't get prosecuted.
$140 a month.
Sad.
That
Taxes, my
have to
mortgage.
be remedied
That's what counts.
as a civil matter.
Meanwhile,
Amazing, right?
the gentleman was prosecuted for something he didn't even do. Doesn't make it.
Just so you
The
know-
law is an ass. Like Eddie said, the law's an ass.
Gene.
You know what I was going to say is, my grandchildren go to school up in Newtown. Unfortunately, there was a tragedy up there in December. One of the things that really drove me crazy was this guy put earplugs in his ears so he wouldn't hear the kids screaming when he was popping them. What I think is happening to the membership is they feel their leadership, along with the people that came in to do the right thing, they got earplugs. They're not listening to them. They're not getting their word to the people that are supposed to be doing